Court will note the appearance of Ms. Kirkpatrick on behalf of plaintiff and Ms. Henderson on behalf of defendant. This matter is before the court on the defendant's motion for temporary custody, parenting time, support, and other relief. Ms. Henderson, you can proceed.
Thank you, Your Honor. Good morning. The parties to this matter have one minor child in common, Lucas. He is 5 years old. He was born during the marriage, and the parties equally participated in the rearing and upbringing of the child. They separated in beginning of December of 2024, at which point plaintiff obtained a PPO against defendant, again, essentially forcing him out of the marital home. And since that time, my client has had very sporadic and short-term parenting time with Lucas. We have reached out to the council several times, and we're only able to obtain very short periods of time for my client, despite the established custodial environment and usually in the presence of a third party. I have not received a response to our motion. However, I do anticipate that one of the arguments that plaintiff will state is that she has concerns about my client's alcohol consumption or mental health. While we do not dispute that my client has had a lot of difficulty processing his mother's death from early of 2024 and has worked through a lot of grief, he has listened to Tiffany's concerns and has done the following since the filing of this matter. He attended AA meetings essentially every day. So in the last 40 days, he attended 38 meetings to date. He has started Vivitrol injections to address any potential cravings of alcohol. He increased the frequency of his counseling to once per week. He also started attending his childhood church for spiritual support, and he obtained independent housing, an apartment that has appropriate sleeping arrangements for him and the child. He moved into that apartment the week of December 30th, 2024. Defendant is seeking joint physical custody of Lucas at this time. If the court believes some sort of graduating parenting time is appropriate, my client will certainly do what the court views as best, but we do not at this point think that the child is in any sort of harm's way or in danger when in my client's care. Several times when my client reached out to plaintiff through messaging as allowed by the PPO, a lot of the times the child was in third-party care, grandmother, while plaintiff was at a bar. So we certainly think that it would be appropriate for the parties to share custody of Lucas at this time. We will also agree to a mutual prohibition on alcohol during parenting time for the parties. Okay. As it relates to child support, Your Honor, parties, we contend, make approximately equal amounts of money. My client is employed at Kellogg Federal Credit Union, making about $82,000 a year. Plaintiff is employed as a counselor, making about $72,000 a year, and either having received or about to receive a $10,000 raise from her employer. The defendant, my client, insures the family for healthcare purposes, and the cost attributable to the child is approximately $120 per month. The daycare cost is approximately $50 per month and currently paid by plaintiff. And since the beginning of the case, my client has contributed to the care and maintenance of the child, as well as household expenses, about $1,200 biweekly. As it relates to the miscellaneous issues, Your Honor, we're asking for the parties to be allowed to communicate via app close or a similar application for parenting and other issues related to the child. Therefore, we're asking for modification of the PPO language. It currently allows some communication, but we just want to make sure it is very clear as to what kind of communication and through what means. Further, we're asking for my client to be able to pick up some property that is currently at the marital home. I outlined the list, but essentially it's all of his clothes and shoes handmade by the children, gifts, some of the Christmas gifts that he has received in the past, pressure washer, leaf blower, and smoker, his late mother's belongings in the totes in the home, his books, his TV that he purchased with his bonus, video games, movies, and Xbox, the spare mattress in the basement, couch from the basement, pots and pans in the second kitchen, and any work gifts from his current or past employers, memorabilia, including blankets, mugs, umbrellas. And one thing we did not put on the list, but would like to add is record player and records. We understand that the removal of that property will have to occur through a third party due to a PPO between the parties, but that would really help my client in setting up his separate household. Another issue is defendant's dog, Gotham. It was his premarital dog. It's a Pomeranian. We're asking for the dog to be able to return to my client as his lease allows for pets to be present in his apartment. Therefore, Your Honor, we're asking for joint legal, joint physical custody in the temporary period of time with equal or close to equal parenting time, child support in accordance with the formula, defendant to be able to remove personal belongings that we outlined from the marital home and his dog, app close to be used for communication, and modify the PPO to allow that as well, and any other relief that the court deems appropriate. Thank you, Your Honor.
Thank you. Ms. Kirkpatrick?
Your Honor, can I ask if the court has received my response to this motion?
Did the court receive your response?
Yes.
No, we did not.
Oh, okay. Like I say, it's a lot. So I'm going to start with the personal property in the home. The only thing out of the list that my client is contesting at this point is the Xbox games and the television and the dog. Any of the other items, some of them he's already taken, the rest of them, my client will make sure that he receives. Arrangements can be made as far as that's concerned. The reason that she's contesting the games and the Xbox and the dog at this time, as they are used by the children in the home, and my client has 2 additional children in addition to the 5-year-old child of the marriage that are currently using those things and are very close to the dog. So, Your Honor,
The client's not disputing it was premarital, though.
no, she's not disputing the fact that he had the dog when he came into the marriage.
Okay, go
And
ahead.
she's really not even considering that he, may end up with the dog. But at this point, she believes that the children want to keep the dog in the home at this point. So, Your Honor, there was a personal protection order that was granted for my client on December 2nd, 2024. The reasons for she sought the PPO concerned mental illness issues on behalf of the defendant as well as alcohol issues. She there had been a gradual incline of incidents with alcohol during 2024, but in November of 2024, it started to get very serious. There were 2 occasions on November 14th and November 17th, 2024, when the defendant came back to the home very intoxicated and had started cooking during the night and passed out, leaving pans on the stove. And she woke up to the house being filled with smoke. Thankfully, no fire. That on the November 23rd, 2024, he also came back to the home drunk and aggressive and woke her up. She was sleeping in order to start a fight. But on December 1st, 2024, he came back to the home. He was drunk and he was aggressive. He lunged at her. He had a knife in his hand. He ended up cutting himself with the knife and through steak knives. All of the children were home during all of these situations because they were all at night. She had to call the police. They took him away by ambulance at that point. And that is when she obtained the personal protection order, and the defendant was not able to come back to the marital home. She has no problem at this point communicating with him by our family wizard or app close, and that being as long as they're talking about the children, that would be fine. But she has a lot of concerns at this point as far as his mental health and his drinking. And all of these things that he has indicated he's doing, you know, by getting the shots and going to meetings, those are all really good things. But she, would like to see some type of proof of any of those things that are happening. And two, she doesn't believe that someone with such a serious drinking problem could be just fixed and okay and safe within 30 days. He's had an inclination towards drinking prior to the death of his mother, Your Honor. He's had 2 drunk driving offenses in Calhoun County in the past. And it's been something that has plagued this marriage from the beginning. And this is why it's ending after 5 years. And so I have been talking with defendant's counsel, and we have worked out several occasions where he's able to have supervised parenting time with the children. He had all Christmas Day with the children. My client brought some gifts for him to give to the children at her folks' house. He has gone many times during the week and on the weekends to her folks' house and to different friends and neighbors, so that he was able to see the child. And she is doing her best to try to work with him at this point, but there is not a indication at this point that the child would be completely safe in his care were he to have equal parenting time with my client. We do not have an objection to there being a gradual situation where the parenting time would be increased based on compliance with his treatment and his medical care, to determine whether he was going to be safe for the child in the future. And so at this point in time, I'd ask that you grant my client sole temporary physical custody with joint legal custody and supervised parenting time as can be arranged for the defendant. And as far as incomes of the parties, we're going to take the defendant's word for it that he makes $82,000. That sounds appropriate to my client. Currently, she makes about $50,000. She has a limited license at this point. She's a therapist, and she will be receiving her license sometimes in 2025, at which point in time she will get a raise, but that has not occurred at this point. And so we believe that child support should be set according to the parties' incomes at this point. And as I indicated, you know, that may change as we go down the line of this divorce and she is able to receive additional compensation. But right now she makes approximately $50,000 a year. And so, Your Honor, we are concerned about the risk to the child currently based on the excessive alcohol use and violent behavior and medical health concerns of the defendant. And so parenting time should be as is going to be safe and appropriate for the child. App Close or Our Family Wizard would be fine with us. Anything he's mentioned with the exception of the video games and the dog would be fine for him to have. And we'd ask that he be ordered to fully engage with mental health treatment and treatment for alcoholism and be able to document his progress for us. Thank you.
Okay, thank you. Well, what the court's going to do, the court's heard the arguments in this matter, and obviously there are some concerns, but again, court doesn't believe that the concerns raised to the level necessary for supervised parenting time at this point. What the court's going to do is grant to the parties joint legal custody, and the court will grant to the plaintiff temporary physical custody with standard parenting time, alternating weekends, holidays, school breaks. And the defendant can commence that this coming Friday at on January 17th. And then each alternating weekend thereafter. Court would set support consistent with the guidelines. The parties will each provide income information to the other attorney within 7 days of today's date. The parties would communicate through app close only as it relates to child-related matters, no other extraneous conversation or anything else. The court would allow the defendant to remove the items listed in paragraph 14 of the defendant's motion, that he can remove those on January 18, 2025 at 12 o'clock noon. And that would include the record player and the record. The court would order that the plaintiff not be present, but that she could have a third party present to supervise. And during the parenting, in this matter, the court would order that neither party would consume alcohol nor any drugs during the time that they have the child in their particular care. I'll ask Ms. Henderson that you would prepare that order, submit it under 7 day.
Thank you,
Okay.
Your Honor.
Okay.
Is the court not including the dog? I mean, I know it's a separate
Oh.
paragraph.
No, I'm sorry, I didn't mention that. I was going to include the dog as well.
Thank you very much.
It was a premarital animal, and so the court would return that to him.
Thank you, Your Honor.
Thank you.
And you want 7 day, right, Your Honor?
Yeah,
Thank you.
free to go. Have a good day.
Thank you very much. You as well.